All right, everybody, I think we're going to go ahead and get started on our last panel. This is probably the most directly relevant to those of us in this room. We're going to turn and look at the legal profession itself, and legal education and practice, and ask how we can innovate in that practice to deal with some of the changes we've seen in recent years. If you've looked at your program, this is not Timothy Terrell. Professor Terrell came down with an illness, unfortunately, so we have found a wonderful replacement. She's the Assistant Dean of Finances. Her name is also Brooks, which I'm going to assume that means she's just an exceptionally intelligent person, as all Brookses are. And she actually just finished her dissertation on competition among law schools in regards to the U.S. News and World Report rankings, which are a controversial subject in and of themselves. But I will turn it over to her, and we will get started. Thank you.
Yes, Tim is under the weather, and I'm an unlikely stand-in, so if you'll bear with me. But not to worry, he sent some caustic questions for a few of our panelists. Wouldn't want to disappoint. But in order to address innovation in both legal education and practice, we're going to speak to all four panelists. First, we're going to start with Dean Martin Katz from the University of Denver, Sturm College of Law, and he's going to focus on change within the current law school climate. He's going to talk a bit about the Carnegie Report, which many of you are familiar with, about integrating theory and practice, experiential learning, both in terms of courses and opportunities, and addressing the barriers that law schools face in delivering this type of education and how we might overcome them. Next, Professor Cynthia Nance, the Nathan Gordon Professor of Law from the University of Arkansas School of Law, just recently wrapped up her tenure as dean, and she's going to talk with us not only about the wide range of shifting communication preferences, how technology is affecting law schools, but the operational aspects of how to run a law school and what it takes from day to day in the current climate. Professor Moliterno, the Vincent Bradford Professor of Law, is from Washington and Lee, and he's going to focus on the legal profession and shifting into the history and the crisis management that you've seen in legal services over the years. He's working on a book now, Profession in Crisis, and he'll speak a little bit about that and then share how Washington and Lee is preparing its students in the third year and how they have reformed their curriculum with a wide variety of experiential offerings. And our cleanup batter, if you will, Professor Dan Katz, is going to help us out, and he's from Michigan State University College of Law. He's going to look more at the business model for legal services, how that's changing, introduce the concept of quantitative legal prediction, shifting towards data analytics. Many of you have heard a lot about Moneyball, and he introduces those sorts of concepts in his work. Things like how much does it cost to handle a matter and what the risk and exposure might be, both for corporate counsel and for the client. And then he's going to look at how law schools might make their graduates more competitive in light of these changes. So we hope that it brings it all full circle. And so we want to get started right now with Dean Martin Katz. Thank you.
Thank you, Brooks, and thank you, Brooks. Thank you to the entire Law Review staff. You've done just an amazing job today. And also thank you for including the Katz family here in force. As far as I know, none of us are related. So what I want to talk about is the trying to make law school better and more responsive to the market that we might anticipate for lawyers, and doing this now. I'll mention during the course of the talk, there's a whole lot of the commentators on this engage in what I would call sort of magical thinking about, gee, wouldn't it be great if the law schools all just went away, or the bar exam just went away? And we could talk about, whether those are good ideas or bad ideas, but one of the things that Dean Nance will I'm sure touch upon is, we live our lives very much in the here and now. What can we do sort of with the situation as we find it. And what I'm going to suggest is that, in fact, the situation as we find it is not nearly as bleak as you might be led to believe if all you read was the front page of the New York Times business section, that, in fact, there is a lot of innovation going on. And so what I want to talk about is an initiative that's designed to facilitate that type of innovation. So what I want to do is start out by talking a little bit about the challenges in the legal market. We may be doing this out of order in the sense that, that some of the other speakers on the panel, particularly Dan, are going to be talking about potential upheaval in the legal market of the future. I'll talk briefly about that and how that reflects in terms of challenges for legal education. And then I want to talk about a potential solution that's here, it's now, it's right in front of us, and it's detailed quite carefully and well in the Carnegie report, which I'll tell you a little bit about. And then I'm going to talk about this initiative called Educating Tomorrow's Lawyers, which is designed to facilitate change along the line, change in individual classrooms along the, and law schools along the lines set out in the Carnegie report. So first, let's talk about some of the challenges in the legal market. As Dan's going to talk about, and I'm really looking forward to this, there's a lot of unknowns in terms of what the future of the practice of law looks like. But we do know pretty unequivocally that the practice of law is changing in certain ways, and it's not likely to go back just because the recession ends. And so what we really do know is that competition is high, and it is likely to stay high in the legal market, and also that clients are far less interested in paying for lawyer training. So I can tell you, I think I don't give up too much when I say that when I graduated from a certain law school in New Haven, and I was getting ready to be a litigator, I literally could not have found the courthouse if my life depended on it. And at times it seemed like it did. But that was okay because there was this assumption that I was going to go to a nice law firm and they were going to train me how to be a lawyer. And anyone who's ever spent time at a law firm understands that nothing happens at a law firm that's not happening on the client's nickel. So what that really meant is that there was a really nice group of clients that was going to train me to be a lawyer. And that was great. And that all made sense as long as both lawyers and clients maintained very long-term relationships with law firms. That has changed, and that is not going back. That's not just because of the recession. And so that means is that the old sort of lawyer training model is very largely broken in a way that, as I say, it's not going back. So the question then is how we train the lawyers of tomorrow. And really, there's only a few choices out there. There's law firms doing it on their own nickel, and some of them are. That means charging reduced rates in the first couple years that folks are working for them, and essentially using that money to provide training and time. Some law firms have engaged outside vendors to do the training. Of course, the question is who's really paying for that. And then, of course, there's the law schools. Now, for many, many years, firms, and when I say firms, I'm not just talking about sort of the big, AmLaw 200. I'm talking about firms of all size. I'm talking about government and nonprofit organizations as well. Firms across the spectrum for years and years have looked at law schools and said, well, you ought to do more lawyer training. You ought to do a better job of training lawyers. And for years and years, law schools have said, well, that's not our problem. We don't do that. Well, one of the things that makes this particularly fun now to be in legal education is that that's changing. We're no longer, quite simply, we're no longer in a position where we can do that as law schools. So the challenges for legal education are actually wonderfully straightforward. We need to make our students competitive for good jobs, and we need to do so at reasonable cost. In other words, we have to think about the value proposition of legal education. Now, I'm going to focus mostly on the benefit side rather than the cost side, and it's a much longer discussion. Brooks actually has as much insight into this as anybody about why the costs of legal education are not likely to come down a whole lot in the foreseeable future. So the real question is, what are the benefits we're providing for that cost, and in terms of making our students competitive for good jobs? So there are a whole lot of unknowns about what it takes to train lawyers for tomorrow's legal jobs, but there are also a whole bunch of things that we actually do know. Lawyers, even in the age of automated and more packaged legal services, are likely to find the good jobs in the law because they're high-level problem solvers. And so our task as law schools is to teach and develop professional judgment, which really does have a meaning. It's about taking the existing knowledge and methods and applying it to new problems. Now, one of the things we have going for us is that we're not alone. There are a number of professions that this is what they do when they train the next generation of professionals. And the Carnegie Foundation has studied at great length how various professions train their new entrants. And so in 2007, the Carnegie Foundation came out with a report called Educating Lawyers. And what they said, and what was interesting about this study is it was the lead author, this guy named Bill Sullivan, and he is not a lawyer. I believe he's actually a sociologist, and a really good one, and he studies how professions train their own. And what the Carnegie report says is that the things that we can do a whole lot better as law schools is, first of all, increasing the amount of experiential education we provide, particularly after the 1L year. And that in that experiential education, what we're trying to do is combine 3 different types of learning which tend to go on, or at least could go on, in the law school class. So there's the typical knowledge, right? Brooks, would you please recite the holding of whatever it is, right? We do that, day in, day out, and that's very typically what law school teaches knowledge quite well, actually. In the last few years, there's been a move toward teaching skills more. We are probably doing a better job of that, but for reasons I'll talk about in a few minutes, we haven't done that good a job of teaching skills. And then professional identity, I'm not talking here just about ethics. I'm talking about this notion of what it means to stand in the role of a lawyer, what the role is really about. And what the Carnegie report said is that the ideal legal education would combine these 3 elements or apprenticeships. There's a nice analogy that they use to describe these 3 things, knowledge being the head, skills being the hands, and professional identity being the heart. So the idea is to combine all 3 of those things in experiential course offerings. Now, this is where this Brooks starts to sweat, because what I'm talking about sounds really expensive, right? Because really there are 3 different ways that we tend to do this. Most often when we think about experiential education, we think clinics. And clinics are wonderful, don't get me wrong, but they are the most expensive form of legal education known on earth. The cost of each seat in a clinic is just staggering. But there's also other types of Carnegie-style education available as well in externships, and also course simulations and lab components to courses. So the question, we have a pretty decent solution out there in terms of trying to produce more practice-ready lawyers, and don't get me wrong here, I was a partner at a law firm. I understand the limits of what a first-year out-of-law school lawyer can do. But the goal here is to produce practice-ready lawyers in the sense of being able to provide some value to a client the day they walk out of school. And that's within reach. And the Carnegie report gives us a pretty good template for doing that. So there are a number of impediments to that type of education. And I'm going to divide those between impediments at the institutional level and impediments at the individual level. At the and in both cases, I'm actually going to assume that either the institution or the individual professor wants to do this type of education. If not, that's a whole different set of impediments, and we can talk about that. But even assuming interest, there are problems at the institutional level with status, with people not talking to each other. So, for example, clinicians often don't trade teaching secrets with podium faculty or legal writing professors. Quality control is tough. A lot of experiential education is done by hiring adjuncts or, as I said, using externships. Maintaining quality control there is tough. How many dollars it takes for each opportunity, each experiential opportunity, that can be an impediment. What about other types of priorities, right? The school is, yes, at one level, their goal is making you all practice-ready lawyers. At another goal, at another level, they have some possibly conflicting priorities. The scholarship that the faculty needs to do to maintain the school's reputation, and also to make sure that we're carrying out our missions as creators of knowledge. And of course, there's the ever-present U.S. news pressures that we face as deans. There's not a dean in the country who will tell you that U.S. news is not an important factor in the way law schools get run. And then there's student expectations. So even schools that have all the best sort of goals and take steps to provide this experiential education, what happens when the professor who's doing this gets beat up in their student evaluations? Is something going wrong there? At the individual level, it's actually a little bit simpler. Anyone who's been a dean or a law professor understands that world's pretty simple. It's about money, time, and respect. And if you sort of provide those things, then stuff happens. And if you don't, then what you want to have happen doesn't happen. So, as I said, there's a whole bunch of people who have made a career recently of bashing law schools, of sort of talking about how we ought to overhaul law schools in the legal system. We should just make law schools provide more skills and skills teaching. We should make law professors do it. I don't know who's going to do that. There's people who think the problem is scholarship. Incidentally, I can tell you at least at the schools that I've seen, it's not the overlap. I get to grade all of the professors at my law school, and I grade them on teaching, scholarship, and service. The overlap between the best teachers and the best scholars is north of 90%. The problem is not that people are doing scholarship. That enhances teaching. People have said, oh, well, the problem is the hiring process, and that in turn, is the faculty governance process. Anyway, all these, we can talk about any one of these factors, but at least for me, they're less interesting because right now there's not anything that we can do. Even if you assume that these were the solutions, there's not much we can do about this. But what we can do is facilitate, both at an institutional level and at the individual professor level, more Carnegie-style learning, more experiential education that builds on these three apprenticeships, the head, the hands, and the heart. And so if we think about it, at the institutional level, one of the things we can do is share knowledge. And also at the individual professor level, we can share knowledge. And we can also, that saves time. And then it also, we can take steps to both provide a little bit of funding and some respect. So what we've done at the University of Denver is we have started this initiative called Educating Tomorrow's Lawyers. And the website's here. It's very easy to find. And it does two things. At the institutional level, it creates a consortium of schools. There are currently 20 schools in the consortium. They are from the top tier to the bottom tier of U.S. News. They are from the West Coast to the East Coast. They are public schools. They are private schools. And the unifying feature is they are all committed in their mission statements to increasing the level of experiential Carnegie-style education that they do. And it's amazing how many wheels you don't need to reinvent when you're talking to other schools doing the same thing. We're doing the same thing at the professor level. So what we've done is we've got a set of course modules that are very rich. They include video, for example, of what's going on in a particular class and what works and what doesn't work. And it has the professors explaining what they're doing. And so we have these modules of exemplary courses in experiential education. Again, the whole idea is you don't need to reinvent certain wheels. I'll leave you with a story about why and how I know that this can be successful. We have a professor at the University of Denver named Roberto Carrata. He's actually one of the national leaders in experiential education. And he spent about 15 years developing what has to be the coolest course I've ever seen. I want to take this course. It is a labor law course where instead of facing forward and getting lectured at about the cases in labor law, the students form a union. And they negotiate with poor Professor Carrata about things like the terms of what the grade will include and what should be on the exam and all sorts of things. By the time they're done, they learn more about labor law than any other possible imaginable way. But what's really encouraging to me about this, Professor Carrata's course is on educating tomorrow's lawyers, and if you can go check it out, as I say, this video of the course election and someone was picketing. It was really fun. But what's most encouraging to me about this is I know one other professor then at our school was actually able to take this course and deploy it herself. So 15 years of work went into preparing this class, and she was able to take it and teach it pretty darn well the first year she did it. That saves her time. It gives her respect. The students loved it. And the other thing we do at ETL is we do provide stipends to professors who post their courses. So it's about time, respect, and money. And Educating Tomorrow's Lawyers is designed to facilitate in all those areas. Thank you.
Well, thanks for being troopers and hanging in there late at the end of the day. We know that we're between you and the cocktail hour, so we all are cognizant of that. Thank you so much to the hospitality that I've experienced from the Law Review students. You guys are amazing, and what a well-run program. You should be very proud, and I know your dean is proud of you. Well, there's been a lot of writing and talking about curricular issues, and so I thought I didn't see anything out there about how to actually run a law school in light of the economic constraints that we're facing in a changing market. So that's what I want to talk about, a little bit of a different focus than the actual curricular issues. I think that law schools need to be making some changes as far as administrative and financial viability because of the economic landscape. And my focus here is to continue to provide quality, relevant education, the public service mission, and also to remain relevant to broader constituencies. So deans of both public and private law schools are finding themselves having to do more with less. And some of the causes of these problems, particularly, I'm going to focus a little bit now here on state schools, is that legislative funding for state schools has decreased dramatically. Even before the states found themselves facing dramatic decreases in revenues, a lower portion of the state budget that relegated to higher ed was shrinking, even as there's a concurrent increase of the number of unfunded mandates from the legislature. Endowment returns reflect the low interest rates, and many private donors worried about their own financial circumstances are a bit more constrained in their giving, though I understand you all have had a really generous gift lately. The increased number of law schools, along with the declining enrollments, mean tuition dollars are shrinking at the same time that the need for financial aid is increasing. This is all true while the cost of many of the basics of legal education and overhead are increasing. We still have utilities, electronic library resources, building, maintenance, travel, all those things. On the other side of the equation, the economic downturn is restructuring the legal employment market. Graduates are demanding more from their law school placement offices, and as you know, there are a number of very high-profile lawsuits out there about law schools misrepresenting placement numbers, or allegedly. Debt load and shrinking student loan resources are other issues that put pressures on deans. And then something that gets lost in the discussion is the fact that there is a societal cost to all this. That is, that students who may have considered a career in law, and more importantly, those who may have a public interest or service bent, may now be disinclined to attend. And those who do are unable to afford to enter public service careers. Moreover, the potential former students are potential donors, and the prospect of permanent disaffection can affect not only school reputation, but the reputation and applications to the law school as well. So what are the changes that I think we need to see implemented to deal with some of these structural shifts? First, just a few words about academic issues, because my fellow panelists have given this a very thoughtful analysis. First, I think you're going to see an increase in interest in grant-funded research, whether that means internal university research stipends or funding from federal agencies or foundations. The reasons for this are numerous. The grants bring new resources for the school, they're prestigious, it's entrepreneurial research, and it mirrors many other departments in the university with long-standing external funding. I think that law schools on many campuses, unfortunately, have been kingdoms unto themselves. And the reality is that it's more important than ever to be viewed as a team player. At the same time, there's an increasing awareness or recognition by universities that the problem of siloed approaches to today's social problems. That is an unrealistic approach and hampers creativity. So what you're seeing at many major universities in the country, and I think someone mentioned this earlier today, is an increasing number of interdisciplinary centers. I know here there's an emphasis on law and religion. These centers are designed to accommodate scholars from across the university. Examples of this are sustainability, educational policy, service learning, international and domestic economic development, and national security. An impediment to this approach that I think law schools will need to address is their rigid tenure and teaching requirements. There needs to be a shift in thinking about what counts as scholarship, which courses are counted in terms of a faculty member's load. The other impediment to this is the way that universities look at tuition dollars. Universities look at what's called FTEs, full-time equivalents, and you have fights between or disagreements between departments about co-listed courses and who gets to count those students. So I think that those changes need to take place at a university level. And until they do, there are disincentives for a school or college to share precious resources. So the removal of these institutional impediments would result in more joint appointments for faculty and additional degree opportunities for students and better solutions to interdisciplinary problems facing today's society. All law schools, but particularly public law schools, need to do a better job of being clear about the value they add. I don't think there is a broad recognition of the public service provided by law schools or the contributions that we make to broader society. Our multiple clinics, externships, pro bono programs, as well as the faculty's service on boards, commissions, and committees in the community, drafting legislation, jury instructions, educating the public and young people about the law, all need to receive higher value and all need to be publicized more, not only to the public, but to legislatures. At many schools, there's a report submitted on all this service to the provost, and it lies there. Nothing's done with it. And that's a missed opportunity, which leads me to my next point. I think that law schools need to be much more savvy about communications generally, whether it's sharing about the programs and resources of the school, about public service, about educational programs, speakers, and reaching out to alums. You know, the old days where you open your mailbox and there's a 50-page glossy magazine, I think, if not coming to an end, should be. By the time the reader gets it, it's outdated, it's not green, and it's expensive. Schools need to develop their social media savvy. I think the communication strategy needs to be a lot more proactive, given the real-time access to information today. How many of the students here look at Above the Law? There immediately, as something goes on in law schools, a dean writes a letter to students explaining why you can't get jobs, whatever. It's posted on Above the Law. If you don't have a proactive communication strategy, then you're backpedaling, and that gets posted on Above the Law. I'm not saying that Above the Law dictates the approach to communication, but I use that as an example of how quickly information gets out there and the need for law schools to be proactive. The second thing is that the reality is that the web, the cloud, is increasingly where our students, applicants, and alums get their information, and we should be there. It's less expensive than the printing, and once you have a salaried person in place, a webmaster, that's not another expense. Also, you can use research assistants in the dean's office to work on some of these tools. And I'll just give a quick example because I know I don't have a lot of time, and I'm happy to speak with anyone about this later. But Facebook, Twitter, Tumblr, all those things can be used very effectively to communicate with students, alumni. It's free PR to other schools, community leaders, and national influence makers. I have a number of faculty from other universities on my Facebook page. Wherever I'm speaking, whatever I'm doing, it's there. 690 Twitter followers is free. Publicity, and again, I think it's something that we are underutilizing in law school education. It's a rare student who wanders in to chat up the dean, but they will privately Facebook or direct message you. The other thing I found out about using social media in that way is that you're able to keep up with alums. If someone has a baby, if they get a new job, we can capture that message and instantly send out a congratulatory note, and that never happened before this media became available. Similarly with law reviews, the movement is toward electronic publication, or at least a website and a blog of current case issues. And it's more interactive with readers and more timely. Several journals in my area, labor employment law, have Twitter feeds which are very helpful, and they highlight interesting issues, emerging case law in the area. Related to that is the shift in what law schools should value as scholarship. We need to rethink about ways of valuing scholarship of junior colleagues who blog or publish electronically. Tax law prof, faculty lounge, work law prof are all contributing value. As this form of publishing increases, faculties need to think about how to value them. Similarly, technology needs to be used to enrich classroom experience. I'll leave that to the next speakers, other than to say things like wikis, video conferencing to get in speakers with expertise are ways to do that. Fundraising with increased communications, as I mentioned before, lead to better relations. We all know there's an increase in entrepreneurial donors, increase in diverse donors, and affinity giving. law schools need to rethink the way we reach out to our donors. Donors are worried about their portfolios, and so we need to be creative. Perhaps an endowment is not the right way to go. Why not ask a donor to actually donate per year for 5 years what that endowment would spend off, $2,000 a year? Creative placement ideas, and I know this is important for the students, video conferencing, tying to the university placement office, taking the career service director out with the dean in alumni visits. Every person who recruits on campus gets a thank you letter from the dean. That person has added value to the law school by coming to interview our students as well. Externships, leveraging them, inviting alums into the law school and making sure they mingle with student mentor programs. In other words, I think that these times call for creativity in all the things and all the hats that deans wear, and I hope these ideas were helpful. Thank you.
Good afternoon. I want to add my heartfelt thanks to the thanks that everyone else has expressed all through the day to everybody here at Emory who's had anything to do with this symposium. It's really a marvelous, marvelous event, and it's been pulled off beautifully, and I'm very happy to have been invited to be part of it, so thank you very much. I can tell that everybody in the room knows that this is the panel to talk about law school, because you've actually configured yourself very appropriately. Everybody is in the back third of the room except for the law review editors. Right? They're the only ones that are brave enough to be up in the front of the room for some reason at this last panel. So I just think that's how it ought to be. My talk is going to be a kind of two-part talk. Part of it, the first part of it's going to be about the profession itself a little bit and about legal education in terms of the innovation or lack of innovation in the history of both of those. And then I'm going to talk a little bit about the innovation that we've undertaken in the curriculum at Washington and Lee that I'm very happy to be a big part of. So that's what I'm going to be doing today. We've heard a lot today. From the morning, we heard about patents, and we heard about all sorts of different issues relating to innovation. We've heard about what stymies or inhibits innovation. We've heard about what motivates it and the like. And so I'm working on a book project now for Oxford University Press that examines the legal profession's history of innovation or lack of it in its own self-regulation. And I'm looking at that through the lens of the history of the legal profession's self-regulation and reaction, if you will, during self-identified crisis times. Times in the history of the American legal profession when it's essentially identified as we're in trouble, something's wrong, we have to do something, we have to fix something. Times like the fallout after Watergate, times like the worry that the legal profession had about communist infiltration in the 50s, times like the legal profession's fear of the arrival of masses of immigrants at the end of the 19th century, and the civility crisis, the litigation explosion, and the current economic crisis that, of course, we all know has blended with dramatic changes in technology and communications and globalization. So what does the legal profession do in these times? After all, it is self-regulating by and large. Unfortunately, the short story, I won't bore you with the long one, the short story is that the legal profession is really ponderous and backward-looking and self-preservationist. The story is that it works very, very hard to resist change. It works very, very hard to maintain its status quo as long as it possibly can, even in the face of changes that are happening all around it in the culture and in society that eventually force the change onto the legal profession, whether it likes it or not. But the legal profession has a tendency to resist those kind of things. I think it's actually as if the legal profession has gone through its life with eyes in the back of its head, but none on its face. It only sees what's behind it, it seems. So the current crisis, we've already heard some about the current crisis, and I won't give you a lot of that, but we all know, it's no secret that the delivery of legal services has dramatically changed in the last decade. We all know that the ways in which law firms are organizing themselves, general counsel offices are organizing themselves, changing dramatically. We all know that the habits of corporate clients in particular in their consumption of legal services have changed dramatically in the last decade. And I would agree with Dean Katz that they're very unlikely to go back to the way they used to be just because the economy starts to turn around at some point when that happens. So we've seen all these changes. What is the legal profession doing about it right now? Now, mind you, I'm not talking about individual lawyers or law firms, some of which are doing very innovative things. I'm really talking about the organized legal profession as an entity. What's it doing about it? The ABA's answer so far has been to organize something called Ethics 2020. Have you heard of this? A body that's working on this? So it's called Ethics 2020, and it's not the year 2020, but it's like Perfect Vision 2020, that sort of 2020. And it is meant, the bar says, to consider changes that are needed in the legal profession as a result of these dramatic changes in technology, communications, globalization. Sounds pretty good, right? But the mission statement for this Ethics 2020 body is, quote, the principles guiding the Commission's work are protection of the public, preservation of core professional values, and maintenance of a strong, independent, self-regulated profession. Do you hear the embedded verbs in there? Protect, prevent, maintain, right? That's what it's about. And unfortunately, if you set out with that mission to look at what changes are going to be driven by these dramatic changes that are going on around the profession, you're quite unlikely to wind up with very forward-looking kind of actual changes. And so far, I think they have not come up with any forward-looking sort of things. It's a problem of our profession, and we're great at what we do. I'm proud to be a lawyer. I'm proud to be a law professor for almost 30 years now. I think what we do is brilliant. But what we do is not especially well geared to forward-looking regulation, to seeing the future, adjusting to new markets, doing those kinds of things. What do you learn about in law school? Precedent. You spend all your time thinking about how to build a case based on what's happened in the past. You're not really looking to the future, except when you're a deal lawyer, you're a transactional lawyer, and even then, you look to the future to try to prevent problems down the line. You don't really grow anything. You're not in the business of growing any business. You're in the business of helping your client, and your client spends his or her time trying to grow their business and do that kind of thing. So it's just the way we're made. I'm going to wind up recommending in my book that there should be a more forward-looking approach, one that allows in and even allows some control by non-lawyers, innovators in business and other enterprises. My hope is going forward, the legal profession can be a little more like Apple and IBM and a little less like Kodak. So that's where that's headed. Now, let's jump over to legal education. Legal education's record of resistance to change is pretty close to the legal profession's record of resistance to change. Legal education's last transformative reforms came in the late 19th century, when Christopher Columbus Langdell, James Barr Ames, and some others at Harvard invented the case method, invented the case book, and invented the basic curriculum that remains the staple at nearly every U.S. law school 130 years later. Sure, there have been changes between then and now, and I don't dispute that, and I'm thrilled at many of them. But the core of what they did in that transformation is still the core of what we do in law schools today. It made sense to do it at the time they did it. It was part of a larger move among many disciplines toward scientification at that period of time. It was meant to make everything in higher education feel like, at least feel like, a hard science. right? And so what Langdell did in creating the cases and the charts with, they almost look like a West key number sort of system, right? Where it's one thing that follows from the other and then it subdivides into three things. It sounds like biology. And it looked like biology. And it tried to imitate geometry in the sense of being kind of proofs from axioms, from basic premises and things like that. So it did what it needed to do at a time. But there was one fateful choice that was made in this reform. Medical education, which was being reformed at the same time, decided that its role was to create doctors. Legal education decided that its role was to create law professors. And that was the target of the teaching, and that was the target of the ways in which law schools were organized and structured. It intentionally disconnected, legal education intentionally disconnected from the practicing branch of the legal profession, much to the dismay of some of the old line professors at the time who were not happy about some of these changes, but we're still recovering from that choice. Medical education went in one direction, legal education went in another, and we're still trying to deal with the fallout from all that. Now, periodically, legal education has been criticized as being disconnected from the profession, sometimes by the profession, criticizing legal education for being disconnected. And right now, in the current crisis, and we've heard a little bit about it already from my two prior speakers, legal education is really in the crosshairs of multiple shooters. Law firms and other legal employers, law firms' clients, GCs, business people alike, prospective students, the New York Times. You know, after all, everybody, every one of our constituencies is demanding that we do more. And I don't mean to sound like a lot of gloom and doom, because I'm really happy at this moment, because this is the best time in my 30 years of trying to do these sorts of things to be a legal education reformer. Everybody wants us to do better, and now's a chance for us to do better. So I'm going to go ahead and describe a little bit of what we've tried to do at W&L, and I suggest that our reform is one reform, and others have other fabulous ideas, and I just want to hear more about all the different things that we might do in legal education to do better than we have done up to this point. Now, I have to ask for your support. One of my goals, you know, my PowerPoint is always in the running for least sophisticated at any conference or symposium or anything like that. So I think I've got a shot today. I've watched all day, and I think I'm in pretty good shape for that dubious honor. So I really do hope that you'll support me. So what have we done at W&L? We have essentially allocated the third year of legal education to experiential education. Everything that the student does in their third year is done in the role of a lawyer. Now, I'll talk more about exactly what that means in just a minute. But what's happened, it's important to remember, hasn't changed the first year, hasn't changed the second year, right? So for anyone, and there are some of my colleagues around the country who think that what we've done is sort of abandon all of the traditions and all of the good things about legal education, nothing could be further from the truth. The first year still has its magic, and everything we do in the first year is taught the way we've always taught the first year. And the second year is pretty much what it's always been. It's that year when students, by and large, collect these courses that are part of the central legal canon. They take evidence, they take constitutional law if it's not required as a first-year course, they take tax, they take corporations, they take those courses that we think every lawyer ought to have a handle on. But now what we've done is said, everything you do in the third year is going to be in the role of lawyer. At the center of what happens in these new courses, which I'll describe a little bit more in a moment, at the center is that students learn law the way lawyers learn law, not the way students learn law. So these courses are not, by any means, purely skills courses. They're courses about the lawyer's role in a particular practice setting. They're courses that require the students to do a wide range of activities that lawyers need to do for their clients. And so when the students learn law in our new third-year curriculum, They do it because they have a client, real or simulated, depends on the course they're in. They have a client who needs some service done. And the student needs to learn the law in order to serve the client's needs. So they do things like lawyers do. They solve problems, they go out and figure out what the law is, and they go forward from there. They don't do it as students do, which is essentially, right, to buy a book, to be in a class Tuesdays and Thursdays from 1 to 2:30, and then take an exam at the end of it, which is also a good thing. And we still have students do for the first 2 years. They don't need to do it all 3. Here's the current status of this project. We're right now, in our first year of full implementation of it. We actually started it 2 academic years ago. Both of those were done as a sort of phase-in. We made it optional for the third-year students to take it or not in their third year for those first 2 years. Most of them did. About 75% of them opted in to take it, and a handful didn't, mostly the law review editors, I should point out, because they had other fish to fry that particular year. But nonetheless, we had it as an option, but it was a very popular option for the first 2 years. We learned a lot from the first 2 iterations of it, and now every student is in it full-time, essentially. We did a very extensive early review. We wanted to know how it was going as much as the data could tell us so far, which was not so much, obviously, but we wanted to know as much as we could. So we did very elaborate student evaluations. We did very elaborate focus groups with students who were leaving the courses and leaving the third year. We did a lot of self-evaluation. I interviewed, met with, spent time with every teacher of any of the new courses to counsel with them, to find out how it was going, what was going well, what was going poorly. And I learned a lot about how they were going in the first year. One of the things that I learned, which I think was entirely predictable, was that the students in these new courses were confused about how they'd be graded. How would my grade be determined? So what had they had until that point? They had taken a course with no feedback whatsoever for an entire semester. They go into an examination room at the end of the course. They write for 3 or 4 hours. They put that chunk of paper in a box, and a grade would come out the other side of the box. That seemed to me sort of mysterious. It always has seemed to me a little bit mysterious, but it was the mystery they know. And after all, those who were at the top of the class were pretty sure they had figured out that mystery. They knew how to get a good grade in that setting. How am I graded now? They weren't sure. Because after all, they were being graded day by day, week by week, all the work they were doing. Their professional demeanor mattered, the way in which they interacted with peers, the ways in which they interacted with their supervisor mattered, the ways in which they engaged the work, and so forth. They weren't sure how they'd be graded, and so we're working through that. One of the things that the teachers of the new courses said to me after the first year was that some of them said they were disappointed that the students were good students, they were smart, and they would give a good answer to whatever question was asked of them, but they didn't sort of take the problem on as their own. They didn't treat this as if they had to take the responsibility and the initiative and solve this client's problem in some creative way. And they wanted them to do that. So what did I tell them? I told the teachers of the courses to tell their students that's what they'd grade on. Tell them that's what you value. Give them a list of the attributes of the work they're going to do and the ways in which you want them to do it so that they'll get the most out of this course. Tell them what you're going to grade on, explicitly, clearly. And what happened was that the students, at least every student who had the capacity to have that kind of creative thinking and initiative and all the rest, they started to do it. And so they started to begin to grow in the way that we hope they will. We actually, at the end of this early review last year, we had, I think it was 4 faculty meetings of 3 hours each to talk about everybody's dreams and hopes and wishes and concerns and beefs and whatever it happened to be. And at the end of that, we made a tiny tweak, which I'll tell you about in just a second, and we got an enormously overwhelming vote of confidence from the faculty that we were doing this right and we were on our way. So very quickly, what is it? Each semester of the third year, fall and spring, begins with a 2-week immersion. None of the other classes start during that 2-week period. So essentially, the entire third year class is hours, 9 to 5, working every evening, working over the weekend. The students react to these by saying that they're remarkably job-like. They're kind of astonished that this is a very intense experience, and they work through it. The fall one, the one at the beginning of the fall, is litigation-oriented. The spring one is deal-oriented. So each of them in the spring one represents either the buyer or seller in a transaction over the sale of a furniture business, and they work through that. So that's how each semester begins. The rest of the semester, the students spend in these experiential courses. For every student, sometime during their third year, that means one of them will be a live client clinic. Every student's going to take a live client clinic. After that, they take from among a menu, we now have about 30 of these that we're offering, and we're going to keep getting more up and running, of courses that are these elaborate simulation courses. So instead of a course called Bankruptcy, we have a course called The Lawyer for Failing Businesses. And the student learns a ton of bankruptcy law in the process of being a lawyer for a failing business. They get a call on the first day. You know, that payment that we were expecting didn't come in. We're looking at Chapter 11. What should we do? And they work for the whole semester trying to represent this particular client. We have other courses that obviously put them into the role of a lawyer in a particular practice setting, and that's how they spend the rest of the semester. There is a service requirement for 1 credit that they have to comply with, and we have a 1 credit course on the legal profession itself, which is essentially about the culture and the economic systems and kind of things about the legal profession that you wouldn't otherwise learn. The tweak we made was to leave room for 1 traditional course per semester if it's needed. So every student is taking a full credit load of experiential education, and there's room for 1 traditional course for whoever needs it. Student gets a clerkship offer and they want to take federal jurisdiction, they can take federal jurisdiction. They're going to be okay to do that. So my point in this is that it's astonishingly doable. Every law school in the country has clinics. Every law school in the country has at least a few of these courses that are really built around some simulation. Some have a lot more than others. So all that we've really done, quite frankly, is staff up more of those courses and require it. It's really about making a statement that experiential education in your third year is just as important as the first year courses in your first year. We require you to take all those courses. We're requiring you to take from a menu of these experiential education courses in your third year. It's doable because there's a lot of room for faculty who don't want to play to stay on the sidelines. There are a lot of my faculty colleagues who have teaching their first year course, teaching their second year course. They have nothing to do with this whatsoever. So it has what I call a leave us alone factor. And you can get this done at a law school if there's enough of a leave us alone factor. What's happened in the end is that we thought it was going to be more expensive. It turns out that it's not. And the reason it's not is that we have formed very important partnerships with a lot of the best lawyers and law firms in Virginia who are teaching about 1/3 of these new courses in the third year curriculum. So some of the best merger and acquisition lawyers from Richmond come over and teach our M&A practicum course. Some of our best bankruptcy lawyers in Roanoke are coming up to teach that course. And the combination of our own faculty teaching some of those and other courses being taught essentially as a donation by members of the practicing bar, and excellent ones, has meant that it turns out it's not any more expensive than it used to be to run our law school. Thanks very much.
Well, I want to thank Emory Law School and Emory Law Journal, as well as the Thrower family, for asking me to be here today. It's a great honor, and I really appreciate the opportunity to be on a panel. I'm really excited about the various innovations that we've heard about, and I want to talk to you about one other piece of the puzzle. And some of this is, I've given this talk a number of times, and some of this is going to be a bit, people aren't going to like it, but I'm going to tell you the truth as I see it. Here we go. I'd ask you not to fool yourself, because the legal employment crisis is more than just a recession. There are two things happening at once. We have a structural and a cyclical problem. The cyclical problem is the recession. When GDP increases, then there's a strict relationship between GDP and the number of law jobs. The structural piece is started before the recession. Here's the graph. We've had about zero net job growth in this industry since the year 2000. The other thing that's growing are what they call other law jobs. That's the technology jobs. Those other, the jobs, the technology jobs are taking the other jobs away, and those jobs are not coming back. Welcome to Law's Information Revolution. Revolution already in progress. My friend Larry Ribstein the late Larry Ribstein wrote this paper, and I would encourage you to take a look at it, because it basically sets the conditions for what is happening in our industry. What I'd like to do is sketch out where I think we're heading and start by talking about a few broad trends. Number one, this is the era of big data. Increasing computing power, decreasing data storage costs is fundamentally altering the scope of scientific and technical possibility. This point has been made in major publications: Nature, whole issue of Nature, Science, The Economist, Science, McKinsey. Of course, they're always a little late to the game, McKinsey. That's on video. That's fine. I don't mind. But that means it's reaching out to business leaders at this point. They're getting hip to this idea. And in our industry. You might say, big data. What's big data? They keep talking about this on the television, like the cloud. What is the cloud? I know there's this thing called the cloud. Well, let me just try to explain briefly if I can. What I just explained to you before briefly is Moore's Law. That's what's driving a lot of this, but I want to explain what big is. So to understand what a petabyte is, you need to understand what a gigabyte is. A gig will store about 7 minutes of video, of HD video, and there's 1 million of those in a petabyte, or petabyte, however you like to say it. So a terabyte drive is something we have now. That's 1,000 gigs. 1,000 of those is a terabyte, or is a petabyte. I just want to show you, just to make clear, how much data storage costs have come down. In 1998, the 1 gig drive, what would be a very cheap thumb drive now, is $228. Now it's 88 cents. When they give those away to you, they haven't given you anything. I'm so sorry. They're giving you like $1, okay? So don't feel like, you can take it for what it's worth. $1. 15 petabytes is the size of all of the pictures on Facebook, all 100 billion of those. All the hard drives manufactured in 1995 collectively are 20 of those. And here's the one I love. The entire written works of mankind in every language is 50 of those. Fossil Storage, which is one of the biggest storage companies out there, has predicted that in 2 to 5 years you'll be able to buy a single petabyte hard drive for $750, which means for $37,000 you could store the entire written work of humanity. That's what we mean when we say big data. What are the implications for legal information engineering, which is the industry, what the industry is going to become? That's Richard Suskind's prediction, and I'm certainly there with it. I'm just filling in some of the details. What that means is on your laptop, you could store every written decision in United States history, all 5 million of them. You could, enterprise level, you could store all of Pacer for about, $10,000 to $20,000. You could store every one of the 100 million documents on Pacer. I'll get to why that's important in a second. Okay, so having all this data alone doesn't really get you anywhere. So here's the other half of the puzzle. Data is AI, computation and artificial intelligence. That's the other half of the equation. And on that side, the AI revolution is very much on. as pointed out in Wired. But it's not what we thought. It's not robots with empathy, okay? Maybe someday, but not today. What it is it's computers mimicking human processes and doing them at scale. That's what soft artificial intelligence is. That's what we have right now. We do not have hard AI, but soft AI is sufficient for the purposes we're talking about. Mark Andreessen is one of the leading venture capitalists out there. He also founded a company called Netscape, you may have heard of. I may be dating myself, that's fine. I'm not, but this is what he says. Healthcare and higher education, in my view, I can't be dating myself, I'm the youngest person on this panel. And on any panel, but this is what he says. Companies in every industry need to assume that a software revolution is coming. Healthcare and education, you read this article, you just cross out those words and put the word law in there. Now, what you might say? I'm X number of years old, I might be able to make it to retirement. If I was under the age of 45, I would get serious about this because this stuff's coming down the pipeline. If you don't believe me, go watch this video about Watson and what Watson can do. There's two of them here. The slides will be available online. I'll give you the URL. This is an article. That's me in Slate. The robots are coming. The key is to be the person who's on the robot side. Okay? If you're against the robots, we've seen Terminator. It's not a pretty picture. Okay? I kid because this is very grim, right? This is a very serious situation, and you need to see it as such, or don't, and then you can join the newspaper industry, okay? These are the terms that are going to drive the future of our industry, and will be part of what it means to think like a lawyer. Now, I go out and give these talks, people cringe, say, you can't replace what I do. Well, we'll get to that in a second. NLP, knowledge representation, feature extraction, feature selection, machine learning, classification, and clustering. I remember that in law school. That was like right between contracts and torts, right? God, we have too much of the bottom and not enough of the top. That's the problem. You got too much substantive expertise and not enough of the other. A little bit up there goes a long way, married with substantive expertise. Let me give you a concrete and meaningful example. This is in the New York Times. E-discovery. That was a law job. Not anymore. That's an IBM job. That's an EMC job. That's a semantic job. That technology took that away from lawyers. Of course, the key is that there are lots of lawyers that are involved in building these types of technologies, but if you're on that side of the equation, it's a boom time. Peril and possibility simultaneously. I just wanted to, e-discovery was not a mainstream thing, and now it dominates the industry. These are the big tech shows in our industry. I just spoke at Legal Tech. I was the only law professor there. I'm sure you guys will be there next time. So what's the next big thing? E-discovery, very interesting. It's a big deal. If you have 100 million emails, you're going to have to find some way to go through them. Quantitative legal predictions, the next thing. This is the road I typically hear. You can't replace the things I do with a computer. You sure about that? Useful to consider an industry where human reasoning was paramount. Finance was an industry where human reasoning reigned supreme, but not anymore. Quants have taken over the industry. There's no qualitative finance out there, really. There's not a journal of qualitative finance. It's a journal of quantitative finance. Watch that 60 Minutes video. If you don't believe me, you can take a look online about that. So let's talk about prediction. Think of two complex systems. One, weather. The other, tides. Weather is not easy and predictable. I've reversed that. Tides are easy and predictable. We have tide tables. Weather, that 14 days is about as good as we can do, and then an almanac, it converges probabilistically on an almanac. Now, different systems have different levels of chaos associated with them. So I live in Michigan. Predicting the weather in Michigan around this time, you're going to do pretty well. It's going to be cold. There you go. And I can give you a very good point estimate as to how cold it'll be. April's a whole other story. April's a chaotic system. Could be 30, could be 80, within 2 days of one another. It crushes the soul. So here's the thing. The almanacs were a huge deal in human history. We're in the weather business here. But if you have an almanac and the other guy doesn't, you're going to do much better. But no one walks around with an almanac and acts like they can have a tide table in their hands. So that's what, it's important to know what caliber prediction is possible. And the key is this, you just have to beat the human reasoners. You don't have to do better than some benchmark of 100%. They went through this whole thing in e-discovery and they came to this conclusion. Humans are not good at coding documents. Machines are beating them. That's what the whole take at the last, at the tech show was. We're switching to the machines. We'll maybe use a seed set that's coded by humans, but then we're going to use machines to do e-discovery. Underlying system variability matters, the quality of the inputs you have matter, etc. There's a formal treatment of this in science about how hard it is to predict something. And that's true for us too. And you want to know, I have a prediction and I have some quality estimate about that prediction. That's what you want to know. Here's the thesis of what I have to say. Human prediction is the hallmark of the legal services industry, and the race for the future is in developing processes that take what human reasoners do, but do them at scale. What do I mean by at scale? How can you aggregate large bodies of information? How are you going to do that? If I said, I need you to review 1 million data points, you can't do that qualitatively. What about 100,000 data points? What about 10,000 data points? There are 5 million cases in American law. How many have you read? This is the nature of the question. Can you do better on prediction if you had all 5 million? The answer is going to be yes. The question is what the algorithm is going to look like. That's the open for a particular class of questions. So I want to tell you that this already exists. The industry is already doing this. I'll start with procurement and supply chain management, which is what GCs are in the business of doing. The race right now is whether the GCs or law firms are going to be the maestros. And this is a really nice report from the business school at Oxford about the legal supply chain and managing the legal supply chain. Here's another piece, and this is from legalfeatures.co.uk. Again, I'll put all these slides online. On the high end of the market, GCs want to do certain classes of prediction. They want to manage the supply chain. They want to staff the matter appropriately. They want to make choices about which law firm should we hire and for what classes of matters. Am I getting a good deal? All these sorts of things. This is one of the biggest developments out there. Time metrics. Wolters Kluwer is the parent company. General counsels got together and decided to share a bunch of legal spend data, $15 billion of legal spend data. What do you get with that? You have an app to figure out whether you have, yeah, there's an app for that. There's an app for that. How much does a lawyer cost in this area? $15 billion of data there. GCs are going to use this to grind away at law firms. They've got the procurement division involved in it now. It's like that. They have the expertise in buying all types of other things. They're going to leverage that against law firms. And now they have the data. That's where data is critical. Predicting judicial decisions. About 10 years ago, there was a tournament between experts and law professors. You know, between experts, law professors, and algorithms. The experts, that would be the Supreme Court bar, did slightly better. The law professors got their clocks cleaned by the algorithm. 75% prediction for the algorithm, 59% for the law professors. Sometimes you think a bunch of things matter when it comes to prediction, and they just don't. You can tell yourself a story. The question is, what does the data indicate? Here's what the model does. It leverages some soft AI. It identifies what factors actually drive results, and then it does a prediction. Their algorithm submitted its prediction, and then the machine submitted the human reasoners submitted their prediction. So that's a great example, okay? But you could reasonably call that a toy result. Like that, how much is that going to be helpful? You say, Dan, that's not terribly helpful to me to predict the Supreme Court case. Like it's a nice thing, but here's what the market cares about: disputes. What does the client ask you? Do I have a case? How are you doing that? How do you generate an assessment of that particular proposition? You take a bunch of prior information and you make a projection. You may go out, that's the human reasoning process that we're talking about mimicking. And it's man versus machine, as the parable typically goes. Mental models versus aggregated data. If you could observe 5 million outputs, if you could absorb 500,000, if you could make sure to build a machine that can do analogical reasoning or something of that class, it would be very useful to you. I'm going to skip through this. What is it that you use to make that decision? Text, citation, votes, prior decisions that disputes you've been involved in, some sort of folk wisdom floating around that you've picked up somehow. Whatever that is, that's the stream of information that you're using and tuning to make a choice about whether I say, I think we're going to win, I don't think, the chances really aren't very good here. You could build models like this on the prediction side. I don't know what the metadata is that's relevant. What would the outputs look like? Standard client memo and a statistical portrait of 10,000 cases like your case, similar to your case. IP litigation, there's a firm that's doing this right now out in Silicon Valley. They spun this off from the Stanford IP Litigation Clearinghouse. This is Josh Walker's thing, for those in your room who know him. They're doing this. This is the place where there's the highest data quality, and the disputes are worth a lot of money. So that's the first one of these. I have the data for tax. I have every tax dispute since 1986. So that's 618,000 filings and 4.5 million docket entries. So IP, tax, you see we're just moving across the sphere. So here's the hard part about prediction, I want to tell you. This is what human reasoners are good at, this part. That's the hard part. That's the black magic, similar. What's a similar object to the thing I'm dealing with, especially when the thing has multiple dimensions to it? That's what human reasoners are good at tuning on. Similarity sometimes in computing or in applied math called distance measures. So that's what I do in my scholarship. It's a little different than what most law professors do, but here's just an example. I have this paper in Physica A, which tries to use citation networks in cases to build distance functions. I'm happy to talk offline about that. This isn't a technical talk. I'm happy to have that conversation. Yeah, we have a cute picture out of it, though. 6 degrees of Marbury versus Madison. It's right behind you. So there's a fun takeaway. All right? So the question is what metadata is relevant for doing prediction? That's the key question. It's the same thing that human reasoners that we're all doing. The question is what metadata are you harvesting and how are you tuning it to make an ultimate choice of whether win versus lose or whatever you want to specify, probabilities or what have you. So let me just make clear. I'm happy to talk offline around the Q&A. There are a lot of technical questions here, but this is very practical. We're in part in the prediction business. It's not everything that people do, but it's one part of what people do. And that's what quantitative legal prediction is about. Mimicking human reasoning processes using artificial intelligence in a wide range of applications relevant to the business of law. My lab group is actively engaged in projects relevant to this. Okay? Here's just a few things. You can go online and check them out. I have this site which I built with Julie Seaman here at Emory and Eugene Atchison, who's in computer science here. You can play around with this. We have 30,000 cases in here, Supreme Court cases. We'll have 600,000 cases in there by the end of this year. We're building our own little Lexus. I should also mention that you can come join us in London if you want to learn about legal information engineering. UK's deregulated its legal services market, so you can go to market with an alternative business structure if you want to. And we want to help you get into the mix if that's something of interest to you. I have to shill for a second, okay? Right? Technology, innovation, deregulation, and entrepreneurship, that's what we're doing in this program. I'll skip through that. You can go to the URL. So these are my final thoughts on this question. The study of law can be a scientific enterprise. Langdell wasn't wrong. He just lived in the wrong era. The practice of law will leverage business analytics and engineering. That's our future. I'm happy to, you can challenge me on it. Just, I'm standing on the mound, just remember that. The market for legal services and the market for legal education, we have a date with destiny. We already have quantitative legal prediction. It's not, is this coming or is it not? It already exists, and there's going to be a lot more. In other words, welcome to law's information revolution, and yeah, there's going to be math on the exam. You can follow me online on Facebook and on Twitter and on Vimeo and online at computationallegalstudies.com. Thank you.
Hi. I want to give you an opportunity to ask any questions that you might have. I'm aware of time, and we are standing between you and your cocktails. However, if you do have questions, we have... Wait.
Hi, Professor Nance, you mentioned that it's becoming prohibitively expensive for law students to enter the public interest profession, but at the same time, it seems like legal services are increasingly out of reach for low-income and middle-income Americans. And I'm wondering what you think law schools can do about this in terms of education and maybe giving back to the community.
That's a really good question. That's why I said I think that resolving some of these financial difficulties is really important, because I think that we are losing people. I know some of the innovative programs that are happening, and one of our fundraising efforts is to actually set up foundation endowment accounts that help provide fellowships. I know Northwestern, who else? Several, Penn, maybe several of the bigger schools have very generous support to help folks go into public service. I also know that there's been a pretty good lobbying effort, and there's the debt relief program that's out there. So I mean, there are programs underway. It's just going to take time. But my point in raising that was exactly yours, that I think it's too important to lose those folks who want to do that work. And so we have to be about finding ways to encourage them.
Ask a quick question to Professor Moliterno, because I remember looking at Washington and Lee very closely 2 years ago when I was looking at schools, and I read a lot of the pros and cons about the third-year program, and I know a lot of the critiques were that in terms of the U.S. News and World Report, it was almost like, you know, it's a real risk, you know, you're either going to sink or swim. And I think in the broader sense, maybe since Brooks is up there, it's almost like the U.S. News and World Report's rankings have institutionalized the standard so much that you can't really experiment and innovate as a law school without risking, you know, this loss of reputation. And it just seems like, how do you get around that? I mean, is there any way to get out of the system, or do you have to wait till top, you know, 5, top 10, top 14 schools start actually trying some of these things, which I don't see them doing anytime in the near future, you know?
Yeah, I mean, it is a tough question. It's a very interesting one, and there's no question but that folks at WNL care whether our ranking goes up or down and all those kinds of things. It's just the way it is. I would say that so far we haven't seen any diminishment in our academic reputation rank, which is the one that would drive that sort of change. And, you know, the program's been announced now for 3 years. There have been 3 sets of evaluations filled out by us, by the academics who fill those out. Our reputation rank has actually risen in the reputation among lawyers and judges, as it's turned out. And so, you know, my expectation is that it's not going to be costly in any of those sorts of ways. And the evidence so far is that it's not costly, and if anything, it's on the direction of being beneficial to those sorts of things. The U.S. News, you can't avoid caring about it because it matters. It matters to students, you know, who are going to graduate, and the value of their degree is in part dictated by those sorts of things. You know, but I remember a dean of mine when I was at William & Mary who said that if what we really wanted was for our ranking to go up, he had a number of ideas that would do that. One of them was to start to go to sporting events, major sporting events, and give out applications to law school with T-shirts and so forth, so that we would drive our application numbers up very, very high, and that would have a good effect on our ranking. And the other was to buy every comic book that had ever been printed so that the volumes in our library numbers would go up very, very high, and that would be a great increase. And of course, his point was we should do professionally responsible things and do professionally responsible things that also raise our ranking if we can, and that's marvelous, but we ought not to ignore doing what's professionally responsible in some fear. We did actually, it may be worth knowing that in the first 2 years, our applications went up 30+% each year. Our student applications went up by 30+% each of the first 2 years that we were doing it. So.
a separate question for the panel. I've heard concerns about what law firms and corporate practices are saying and how you're trying to innovate the curriculum, et cetera, to deal with those issues. What I haven't heard is what the law schools are trying to do, if anything, to reduce legal costs, the cost of a legal education, whether the number of years that you spend, or just the tuition itself. What are you doing to make sure that kids don't come out with $150,000 a year in loans that they owe, and not raising money? I'm not talking about that, because that's, you can just go out and seek money for that, but have law faculties, have deans focused on ways, how can we get our costs down? How can we reduce tuition 10%, 20% over the next 5 years? What kind of thoughts have been given to that?
I'm going to let the deans answer that.
Well, I can take a start at it. So there's been at least I think what is the prevailing theory on this right now is that the way that law schools are regulated, there is probably little room for a truly low-cost law school. There may be some range, and right now, if you look at the range of tuition rates that schools charge, and keep in mind some are state-funded and others are not. You can come up with a range in which it probably reflects the cost of simply complying with all of the demands that are put on law schools. I'd say primarily by the ABA, but U.S. News plays a role as well. I mean, we're all competing in this. I mean, it's been compared to an arms race, that sort of thing. Also, the demands our students put on us. So there's actually a tension that we see right now where people are asking for more practical legal education and more opportunities for our students to get to be trained as lawyers are. As I say, those are actually remarkably expensive. So at least one theory is that if we did away with a lot of the levels of regulation that we have to comply with in law school, I can tell you actually in I think 2 weeks I have the ABA coming in a site visit. They come every 7 years to make sure that you comply with a rather thick stack of regulations, and all of those regulations cost money. So at least one theory is that if you could make the ABA go away, or you could sort of completely overhaul the way in which the law schools are regulated, that might open up room for truly low-cost types of law schools. I guess the question, though, I'd still be left with, even if that's correct, what does that low-cost law school look like, and which of the 200 or so law schools in the country really want to be that school? Now, maybe the answer is that, with a few entrants into the market, that there's pressure put and that law schools start to distinguish themselves and differentiate themselves along those lines. But the short of it is that right now, every dean in the country, I think, has looked for ways to save money and reduce the costs of legal education. And I think what we're finding is that there are limits in our ability to do that. And so as a result, at least for us at University of Denver, and I think that's true for most of the other deans that I know, the issue has been how do we increase value, because there's a sense of limits on how much we can reduce cost.
I'll just jump in quickly and say that the deans have raised this issue with the ABA. I think many of you in the room know that the ABA accreditation standards are under review against the backdrop of some of the financial pressures. Rick Matazar has been really outspoken about this. I will tell you, and I wrote a paper about this in Iowa, and a number of the young people interviewed in the paper about their debt was cumulative debt. And so one of the things that I've been advocating is that folks who know they want to go to graduate school or law school plan their debt from the beginning. In other words, if I get you, our tuition is $10,000 a year. It's very reasonable. In fact, it's less than many undergraduate institutions. But if you come to me with a $60,000 debt from Georgetown, and then you want to finance your legal ed, and then you come out and say, oh gosh, I've got, $100,000 in debt. Well, I mean, so part of it is being a little bit more savvy as consumers. And then the third thing is that there's a sense out there that all law schools are created equally. And I think I can speak for the two of us that this notion that we pay people to sit around and think and not teach and all that, particularly at state schools, there is responsive to the legislature wants to see classroom time with even senior faculty members. So again, if I don't have people out of the classroom, I don't have to fund that. And then the last thing is that many law schools, our adjuncts are coming in. We have a number of very gifted, very high-profile adjuncts who actually are donating time as a gift to the law school to offer upper-level classes. And again, that's another way to contain costs. So those are some really practical things. And in the long run, we hope that, I know you said not fundraising, but again, it does help in terms of scholarship support.
I had a question following the presentation of the last cats. Given the innovations that are coming and the changes that are coming in the industry, what types of new skill sets do you think lawyers will need to have to operate in that environment?
Yeah, so at Michigan State, I teach quantitative methods, which has 3 pieces to it. What you'd consider a traditional statistics class. I teach information technology, including the sets of things that go into predicting cases and matters and disputes. And there is demand out there in the market for this type of skill, these types of skills, a person who knows both about law and about these things. These sort of hybrid individuals are, in my view, the people of the future. And so in some other work that I've written, I've talked about what an MIT School of Law would look like. There's been this long-standing concern that we'd become a trade school, that law school would, and that we wouldn't be doing theory. I don't think anybody would accuse MIT of not being a theory house. It's just a different set of theories that they privilege. And in building information products, being involved in that space, leveraging what you know about law. This is not, I hope no one takes the wrong impression. This is not the age of computers as lawyers. This is the age of lawyers and computers working together to be more efficient. And that will just be demanded because general counsels and other people who are paying are simply not going to accept, in an age of technology, the set of processes that have been done up to now. They're getting more sophisticated. They talk to one another. They have the roundtable, the GC roundtable, among other things.
Thank you.
Long day. Thank you, everyone, for sticking it out. And thank you again to the Thrower family for endowing this wonderful event, and to Judge Michelle, and to Danny and Meredith, me personally, because this would not have happened without their help. And thank you to all of our panelists and moderators, and for Brooksy for standing at the last minute. And everyone, go get a glass of wine now. Thank you.